So it's Edward Rose and the Blandings Apartments versus Michaela Menatak and Deontay Jones, 2403372. Good morning, ma'am. Your name? Right up, right there. Have a seat. Sir, your name?
My name is Deontay Jones.
Okay, good morning to you or afternoon, whatever it is. I just don't know why this case has been going on so long. Well, all right. You guys can't resolve this?
An offer was made to the defendant, Your Honor. A very, very fair offer. The defendant's declined that.
What is this about?
This is a claim, Your Honor, for damages and monthly rents on the conclusion of the tenancy. Plaintiff seeking, unpaid rents, late fees,
Unpaid rent, the amount of how much?
total amount being sought, Your Honor, is,
1446.70.
that's correct.
What's the total amount of the past due rent? Okay, now wait a second. I love kids and I'm sorry. I know they're hard to control sometimes, but you're going to have to control the child, please. What's the past due rent amount? And I need the late fees.
Your Honor, the past due rental amount after move out was $295.13. There's also a non-refundable pet fee being assessed in the amount of $250, a late fee of $75, an unauthorized pet fine of $150. And
Authorized pet fine?
that's correct. And rent of $1,006.84.
What's the first thing you said? 295.13.
$295.30.
What's that for?
That's the rent due after move out.
Well, then how are you getting to 1,006 in rent? I don't understand.
The $1,006.84 is being assessed as a result of unauthorized pet that.
Wait a minute, I got 290, maybe I'm misunderstanding. You told me rent was 295.13. You said that there was a pet fee of 250. You said there was a late fee of 75, and you said there was another unauthorized pet fee of 150. Right?
Yes, that's correct.
Well, where's the 1,006 come from? I don't know what you're talking about. You only prayed for 1446.
And Your Honor, I have my agent here to break down all of those amounts for Your Honor. I said, the
Folks, did you have, hang on. Did you guys have a pet there?
No, no, sir.
You did not have a pet.
I'm allergic to cats and dogs. I'm not allowed to be around pets, sir.
You got testimony they got pets?
Yes, Your Honor. My agent will testify that an inspection was performed after the tenants vacated. And as a result of that inspection, there was evidence of urine stains in the carpet.
Oh my God.
Consistent.
How do we know that wasn't from prior tenants? Do you guys have pets? You're gonna be under oath here.
No,
Your Honor, if I may.
Nope, not yet.
Sorry, Your Honor.
I'm just trying to expedite this.
Another reason why is because I have really bad asthma. That's why I'm not allowed to be.
All right, what's the 1,006 for? Your math doesn't add up. It's not even close.
Our statements are a little confusing.
They're not even confusing. They're just not even close. I
The
mean,
payment that's involved in it, you didn't get to.
Yeah.
For the month.
What I was itemizing for the court is what's set forth in the notice of security deposit account. Now that amount doesn't take into account a payment, check payment that was made on May 18th, 2023, the amount of $736.42 as to how we get to the $1446.70. So I was just going through each amount that's set forth in the security deposit account statement. And if the defendant doesn't object, I certainly could present that to the court. I know we haven't begun the trial yet, and that would help the court understand the calculation as to the amount being sought this back.
you didn't come here all the way from Grand Rapids for this. You did?
Yes.
We're not getting rich on this one, counsel. Okay, let's just move on. Why don't you make your opening statement? Folks,
Yes, sir.
can I narrow issues? Do you agree that you owe $295.13 in past due rent?
No, sir.
You don't. Do you think you owe anything?
Do you think we owe the blinds?
The what?
$25 for the damage for the blinds. And there was a little tear in the carpet, but that was from moving out. Our bed frame got stuck on their carpet and it tore up.
Okay, but that, you're still responsible for that.
Willing to pay a minimum of $250, but everything else doesn't really.
So counsel, you're basically, with regard to circumstantial evidence here, that somebody went in and looked and saw urine stains on the carpet and they're assuming there's a pet. Right?
That's correct. That was the assessment.
You don't have any witnesses that are gonna come in and say that they had a pet.
That's correct. That's correct. Now, there,
You have pictures of these urine stains?
yes, plaintiff will present photographs, colored photographs of the damage to the carpet. Carpet was replaced. Was not just, as the inspector noted, evidence of urine, but there were also tears in the carpet.
How old was the carpet?
My agent informs me the carpet was
When
brand
you
new.
say agent, what's the apartment manager at Landings?
That's correct. His name, Your Honor, is Mike Cigaturora, spelled C-I-E, and I apologize. I know I mispronounced that. G-O-T-U-R-A.
All right. Jeez.
Your Honor,
Hang on. No, I never thought it was gonna take this long. I just never thought it was gonna take this long, but now I told the other three. She probably can do the first hour or so. Just find out for me from, I'll tell you what, no, that's okay. Thank you, though. I'll call Amy right now. What? Well, just for, I'm getting rid of. You don't have to. I mean, it's not. Hang on one second. Let me call you back. How long is this gonna take?
Your Honor, I suspect it'd be probably an hour to hour and a half.
Oh my God.
Claims willing to adjourn. I took the opportunity to go through the proofs thoroughly, and I know Your Honor has other obligations. And I understand,
It shouldn't take an hour and a half though, right? You got pictures?
yes. Which I will know for the record were provided to the defendant at the last hearing.
All right, let me get off this bench and figure out what I'm gonna do here for 2 minutes, okay? Stay seated, everybody. We're gonna proceed now. Make your opening statement. I'm back on the record on Edward Rose and the Landings versus Michaela Menatak and Deontay Jones. You can go ahead and proceed, counsel.
Thank you. Christopher Sosson, being on the outlook.
Okay, guys. Do you have somebody that could come and watch those kids or not?
Today, right now.
Go ahead.
Thank you. Your Honor, this is a claim brought by the plaintiff for recovery of balance owing upon the conclusion of a tenancy that existed between the parties. From plaintiff's perspective, claims for breach of contract, accounts stated and unjust enrichment are fairly straightforward. Plaintiff begins to prove here today by concurrence of the evidence. The parties had entered into a lease agreement wherein each party agreed to certain obligations to the other. On February 26th of 2022, parties had entered into a residential lease agreement to lease Defendant a property located at 6805 Lakeview Boulevard, apartment 5311, here in Westland, located in Westland, Michigan.
You know, why am I doing a case in Westland anyway? Go ahead.
for a fixed lease term from February 26th, 2022 through May 22nd, 2023. In exchange for the defendant's promise to pay rent monthly in the amount of $932, in addition to a $500 security deposit. The evidence will show the parties entered into this lease agreement, and the defendant received rental of the property. The evidence will also show that the defendant did not, upon possessing the property, did not complete an inventory checklist at the inception of the lease agreement, or the defendant returned any such inventory checklist to the defendant. The evidence will also show that the defendant took possession of the property was in good and habitable condition. Finally, the evidence will show that upon conclusion of the tenancy, when the defendant vacated, the defendant did not leave the property in the same condition that the defendant took possession of the property, that there were damages to the property that were repaired, and there were unpaid rents. Collectively, all of the evidence the plaintiff will present here today will show by preponderance of the evidence that the total amount of $1,446.70 is owing. Plaintiff accordingly will seek a judgment against the defendant for that amount.
Thank you. Do you have either one of you wish to give an opening statement where you tell me what your theory is about the case? Nice and loud for me. You can stay seated. You're good.
The two.
That was Armstrong.
That they're claiming that still.
Oh, well.
Wait a minute. You gotta shut this off here, Linda. Go ahead.
The 295.13, they're stating that I still owe. They sent me a letter of this date, how much I owe, May 1st of 2023. I have a payment confirmation sent to my email that I paid May 18th for $976.98 and another,
976.
I'm sorry, $576.98. And I also paid May 1st, $307.90 total. If you add that up, that's $742.32 total that I've paid.
Wait a minute. Let's slow down.
Okay.
You were in there for 15 months, right?
I believe it was 16 months.
Let's see. He said he told me February 26th of 22 to May 22 of 23. Do you have any reason to dispute that? And then you're telling me in 23, I thought you said you paid $576.78 at one point,
Yes,
and you paid $307.90 at another point.
yes, sir.
And then you came up with some number. I mean, 307.9, what's that?
That was added up in total,
What was added up in total?
the 700.
576 and 307 does not equal 700 and some.
Plus the 165.34.
All right. Can we just agree that it comes out to 871.91? Is that true? 294.13 and 576.78. Does that not come out to 871.91?
Sure.
All right. And then you added in 165.34. You made another payment, right? And so if I add 165.34 to that, that's going to come out to 5, 12, 7, 13. It's going to come out to 1,037.25. Am I right?
Yes, sure.
Okay, so what does that have to do with anything? He's telling me that you owe $295.13 in rent.
Yes, Your Honor, I got that letter stated May 1st, and I'm telling you the dates that I've paid in May total. So those payments should have already been paid. I already paid those to him.
What other payments? What do you mean? You paid the rent or you paid everything here?
I paid everything.
What says you paid the $200 pet fee?
No, that was for late fees for move out fees. That's what they're saying.
Well, you guys got me confused. I don't know if I'm trying to rush or what. And I sure don't want to do that.
I have
But he's got $400 with regard to the pets. $75 late fee, that's $475 plus rent of $295.13. And then you got some other numbers going on over here. All right, go ahead. Tell me the rest of what you want to say.
Basically, we paid all of our rent. They're just charging us for these late fees for after our move out. I'm basically saying we've already paid all those. We also paid after our move out, I'm sorry. On June 20th, $327.50. So all these payments, our rent is only $932. It's came up to over $1,000.
All right, call your first witness.
Thank you, Your Honor. Your Honor, plaintiff calls Mike Cigatarella to the scene.
Come on up here, sir. Raise your right hand. Solemnly swear to affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
And can you spell your last name, please?
Ciegotura.
Okay, go ahead.
Thank you, Your Honor. Sir, could you please state your name?
Michael Cigatura.
And Mr. Cigatarella, what's your affiliation with Plaintiff?
The billing manager.
Are you employed by the Plaintiff?
Yes, sorry.
And how long have you been employed by the Plaintiff as a billing manager?
Just under 18 years.
And could you describe briefly your job duties or responsibilities as such?
I'm in charge of the department that handles final move-out accounting, assessment of apartments, and billing, and ultimately collections of outstanding debts due to our company.
And in your responsibilities as such, do you also maintain, generate, store, and access records kept by the plaintiff in the ordinary and usual course of its business?
I do.
And what types of records does plaintiff maintain, store, possess, create?
Everything to
You
do.
don't need to do all this for me. Let's just get to the basic. How much do you figure is due for undue rent? That is owed for past due rent?
I guess that needs a little clarification.
Well, let's clarify it. Do the best you can. Tell me how much you think they owe.
So the total outstanding is the 1446 that was filed for, which includes rent balance and damages.
Well, you gotta give me a base. Rent balance you think is what?
Your Honor, may I ask the plaintiff statement this question? Sir, in the normal and ordinary course of plaintiff's business, does it prepare a resident ledger for each tenant?
Yes,
All right. And at some point, the defendant entered into a tenancy with the plaintiff, is that correct?
yes,
And as a result of that tenancy that existed between the parties, did plaintiff prepare, generate, keep, store, and maintain the resident ledger, which reflects payments, charges, credits throughout the entire duration of the tenancy?
yes,
If I were to show you a copy of that ledger, would you recognize it?
yes.
Your Honor, let the record reflect that I presented to the defendant with plaintiff's proposed.
Is it already been marked?
It has.
Okay.
It's proposed exhibit number 3.
Any objection? Go ahead. You can go ahead. You can approach the witness.
Sir, do you recognize the document that I just presented to you?
Yes.
What is it?
Tenant ledger.
For these people, right?
Yes,
Right.
And that's the ledger as it relates to the defendant's tenancy with plaintiff that is the subject matter of this pending action, correct?
correct.
And can you break down as to how plaintiff has calculated the amount?
Okay, you move for the admission of plaintiffs 3?
I'm sorry.
You move for the admission of plaintiffs 3? He can't read off a document unless it's been admitted.
Has that ledger been kept in the ordinary and usual course?
You don't need to do all this for me. Not today.
Plaintiff would move to admit into evidence.
Any objection? Plaintiffs 3?
Understanding what he's saying.
I'm gonna go ahead and admit the document. That's the document, the ledger that tells how much is owed.
Now, sir, is this a ledger that completely reflects all charges, credits during the entire duration of defendant's tenancy with plaintiff?
Yes, it is.
All right. I'm going to ask you to refer to the conclusion of the tenancy in May of 2022 in this ledger. Do you see that?
Yes,
All right. At what point in May of 2023 did the defendant have a balance, and if so, what was that amount?
Ian, after move out or to start the month?
When did the defendant move out?
May 22nd,
Of what year?
2023.
As of May 22nd, 2023, did she have a balance owing to plaintiff of any amounts? And if so, what were those amounts?
As of the move out date, no.
So no balance, didn't owe anything on rent, didn't owe anything on anything else. Right?
Correct. Rent was paid through move out.
Okay, go ahead.
So was there an inspection following move out?
Yes.
All right. And what was the result of that inspection of the premises?
Damages, were found during the inspection.
Kind of damages.
Okay, I wasn't sure if I should list them or not.
Can you go through to itemize the amounts that are being sought in this pending action, which, as you alluded to earlier, also include unpaid rents, correct?
Correct.
All right, so could you go through those amounts, as to how you arrived at the 1446?
Replacement of damaged bedroom blinds, $27.87. Resurface of damaged kitchen countertop, $130. Stain kills in the living room and dining room to the drywall for $8.75. Replacement of the damaged carpet throughout the apartment, $739.53. Rent due to complete their notice to vacate in the amount of $295.13. Non-refundable pet fee of $250. Unauthorized pet fine violation of $150. And back pet rent in the amount of $345.42.
Non-refundable pet fee, $250. Right?
Yes, Your Honor.
$150 for
A violation.
not notifying you of the pet.
Correct, Your Honor.
And then you said $350 for what?
$345.42 is back pet rent.
Back?
A back charge for unpaid. They should have been pet rent.
Okay.
Okay.
How much was the rental fee per month?
For the pet or?
Pet.
For pet is $25 a month.
Okay, go ahead.
And that 345.42, sir, is for back pet rent from February 26, 2022 through May 22nd, 2023.
Correct, for the onset of the lease.
In the assessment of the unauthorized pet fine, the non-refundable pet fee, and the back pet rent was all due to, would it be accurate, the inspection that was conducted after the tenant vacated the premises, correct?
Correct, based on the condition of the apartment.
What was discovered in that inspection that led you to assess the pet?
Do you have photographs?
Yes, Your Honor.
Can you put those in right now? How many photographs you have?
I have 9 sheets on 8.5 by 11 pages.
Good, bring them up here. We're gonna have those marked. What, have you had those marked yet?
I do, Your Honor. Let the record reflect, I'm presenting defendant with plaintiff's proposed exhibit number 4. May I approach?
You can.
Thank you.
What is that, 4 through 13?
Well, just exhibit 3 has been admitted so far.
Right.
This is proposed exhibit 4.
Okay, so, so you have 9 pages on 4?
Yes, that's correct.
Thank you.
9, 8.5 by 11 page sheets. Sir, do you recognize the document that I presented to you?
Yes.
What is that document?
Photographs taken during the inspection of the apartment.
And those were photographs taken by plaintiff's agent upon the conclusion of the tenancy and vacation of the apartment by the defendant?
Correct.
Is it standard, ordinary for plaintiff in the ordinary usual course of its business to take photos when a tenant vacates after a tenancy?
Yes,
And did that occur in this instance as well?
yes,
And are those in fact photos of the apartment that was rented to the defendant that was vacated?
Yes.
And are they, have those photos been altered, changed, or modified in any way from when they were taken to your knowledge?
No, they haven't.
Do those photos accurately represent the condition of the apartment when the defendant vacated?
Yes.
Your Honor, at this point, plaintiff would move to admit into evidence.
Plaintiff's four is admitted. Go ahead. Can I see that, sir? Can I see those? Okay. I can't tell what that is there on plaintiff's four. Can you describe, just go through each page real quick for me and tell me what you've got?
Your Honor, I also have a duplicate I can present to the witness.
Perfect. Perfect. Yes.
Sir, can you go through each page and explain to the court what is depicted in each one of the photographs briefly, please?
Yeah, first page, first photo is a picture of the wall. Second and third photo are, pictures of the carpet. Second page, all pictures of the carpet. Third page is carpet transition into, the kitchen flooring. Last photo is kitchen countertops. Countertop pictures, are all on the next page. Lines in the first photo on page 5, as well as carpet photos, specifically the backing of the carpet.
Looks like a ring. Go to page 7. It looks like a ring around the toilet, right? Can you tell what that is? Tell me what that is.
I believe that's just a shadow. We didn't charge for the bathroom flooring.
Okay, okay.
So,
So,
they were probably just noting, the water stain that next to the tub.
all right, so we're down to countertops. How old were those countertops?
I did not have the age of the countertop.
Ben?
But, sir, would it be accurate, as you indicated earlier, that the carpet was brand new before the tenant took possession of the premises?
That is correct.
And upon conclusion of the tenancy, did plaintiff mail, did the defendant provide plaintiff with a forwarding address?
Yes.
And did the plaintiff, send the defendant a notice of security deposit account statement?
Yes.
And if I were to show you a copy of that security deposit account statement, would you recognize it?
Yes.
Your Honor, let the record reflect that presenting the defendant with plaintiff's proposed exhibit number 7.
Okay,
May I approach the witness?
you may?
Sir, do you recognize a copy of the document that I presented to you?
I do.
What is it?
That's our security deposit, disbursement statement.
And is it accurate that the defendant paid a $500 security deposit at the outset of the lease agreement?
Yes.
And when was this security deposit statement mailed to the defendant?
June the 15th of 2023.
And that was mailed to the address that had been provided by the defendant plaintiff, or forwarding address?
Yeah.
Is this a true and accurate copy of the security deposit account statement that was mailed to the defendant that has been kept in plaintiff's records?
Yes.
Has it been changed, altered, or modified in any way from the date that it was mailed to the defendant and then contained in defendant's records?
No.
Thank you. At this time, Your Honor, plaintiff would move to admit into evidence plaintiff's proposed exhibit number 7.
Any objection?
Yes, actually.
What is your objection?
Photos that they're trying to charge me of carpet damages. I'm not sure if you can see on their photos, but I also have my own over here. From what I'm seeing, it's just vacuum marks from me vacuuming the floor. The dark marks on the floor are just vacuum marks.
All right, there's still been a sufficient foundation. I'm going to admit plaintiff 7.
Thank you. Now, sir, after this security deposit account statement was mailed to the defendant, did plaintiff receive any written dispute as it relates to the calculation of the damages that were contained in the security deposit account statement?
No.
And is it accurate that the statement reflects a total amount owing of $1,446.70?
Yes.
And his defendant, and I presented to you earlier, the plaintiff's ledger. Do you have that in front of you?
I didn't.
All right. Does that ledger accurately contain an accounting of all payments that the defendant has made to date to reduce the total amount owing and being sought in this pending action to 1446.70?
Yes,
Are there any payments that you're aware of that are not accounted for or that are not contained in that ledger?
no,
And now, sir, when the defendant took possession of the property, did the defendant receive an inventory checklist?
yes,
Did she complete that inventory checklist and return to plaintiff?
no,
Did the defendant ever contact you or any agent of plaintiff with any complaints about the condition of the property after she took possession of the property?
no,
Now, sir, as a result of there were multiple tears in the carpet in different areas throughout,
yes,
and there were multiple stains
yes,
throughout as well.
yes.
Were the stains dark stains, or do you know, from plaintiff's records, what caused the stains?
What caused them? Not specifically. There are stains consistent with pet urine stains that we see. There's also the tears in the carpet are consistent with areas that we see where a pet has pawed at a carpet.
How do you know that?
Experience, assessing apartments.
Did you assess this apartment?
I did not personally.
So then, how do you come to the conclusion that the urine stains are those of a pet, tears are those of a pet?
Based on our inspectors.
Well, they're telling you though, you can't. I'm striking all that testimony. You never saw the interior here?
Personally, no, Your Honor.
You can't testify to something somebody told you.
You have seen the photographs that were taken
Yes,
when the inspection occurred. And those photographs do depict stains, do they not?
yes,
And those photographs do depict tears of multiple
yes.
areas inside the apartment, correct?
How can I even have him? Apparently, I really wasn't listening very well because how does he know if this accurately depicts how the unit looked?
He's testified, Your Honor, that in the regular, ordinary course of plaintiff's business, it takes photographs after. it's
Yeah, but
made.
not him. He wasn't in the place.
That's correct, but those are business records that are stored and maintained in the ordinary
Not-
course of plaintiff's business. And they have been admitted into evidence. And he testified as well that based upon plaintiff's policy of storing and maintaining those records, they're taken by plaintiff every time a tenant vacates.
Okay.
And as such, he's testifying that those.
I don't want to hear about any more testimony from him about personal observations of others. I'll admit the photographs. But go ahead.
Understood, Your Honor. Thank you. Now, sir, was the carpet in the unit replaced upon the conclusion of the tenancy?
Yes,
And if I were to show you an invoice that plaintiff incurred as a result of replacing the carpet, would you recognize it?
yes,
Your Honor, let the records reflect that I presented defendant with plaintiff's proposed exhibit number 6. May I approach?
You may.
Sir, do you recognize the document that I've just presented to you?
yes.
What is it?
That's an invoice from Sherwin-Williams for new carpet being installed in unit 5311.
And is this the invoice that you referenced to earlier in your testimony for the replacement of the carpet for the unit the defendant had possessed?
Yes,
And is this an invoice, a type of invoice that plaintiff keeps and maintains in the ordinary and usual course of its business?
yes, it is.
Has this invoice been changed or altered in any way from when it was generated and maintained in plaintiff's records?
No,
And do you believe this to be a true and accurate copy of the invoice
yes,
for the replacement of the carpet for the unit?
yes,
Your Honor, at this time, plaintiff would move to admit into evidence plaintiff's proposal to number 6.
Any objection?
I'm not sure if I object, but I do want to say,
I'm gonna let you testify later, and your husband should be in here. Where's he at?
with our daughter, that she was making noise, he didn't want her to be too
I'll admit plaintiff 6. Go ahead.
Hey, sir, what's the total amount, in this invoice that was charged for the carpet replacement?
$830.70.
I thought you said 739.53 or something.
I did, if I can explain.
Yeah.
That we were invoiced $830.70, as I just mentioned. We only charged the $739.53 taken into account depreciation for the year 15 months that resident lived there.
Okay.
And is it standard, sir, for plaintiff to always include depreciation for the depreciation amount in the valuation of the apartment that
Yeah.
charges? Thank you. All right. Now, additionally, you had indicated earlier in your testimony that upon conclusion of the tenancy, an inspection was conducted, correct?
Yes.
Correct. And you didn't conduct the inspection, did you?
No, I did not.
But an agent of plaintiff did, is that correct?
Yes.
And that's normal in the ordinary course of plaintiff's business.
Yes.
It was an inspection report generated after that inspector conducted an inspection of the apartment.
Yes.
And if I were to show you a copy of the inspection report that inspector prepared, would you recognize it?
Yes.
Your Honor, let the record reflect that I presented the defendant with plaintiff's proposed exhibit number 5. May I approach the witness?
You can, but this is an inspector from your company
This would be correct.
or an outside inspector.
No. From our internal inspection
All right, go
of
ahead.
the apartment.
Sir, do you recognize the document that I've just presented to you?
Yes.
Still double hearsay. I mean, it might be admissible under the business records, but you got somebody else making statements about what they observed and he wasn't there.
Well, Your Honor, the line of questioning would just be to elicit that this is a business record that plaintiff ordinarily creates.
That's all fine and dandy, but you still can't have hearsay in there. This guy is making statements, why isn't that inspector here? Should have brought him in here.
Well, Your Honor.
He's the one who does the inspection. This guy isn't here. And he's coming in here testifying as to what he said in his report and what he thinks photos say when he wasn't there. I mean, I'm going to admit that, but I'm not going to accept any findings that this inspector made on his own because that is now double hearsay, right?
I certainly would agree.
Thank you.
He's not going to be testifying to what anything as to.
Well, but I'm not going to go through and redact the document. If an inspector is making a statement, drawing a conclusion in there that wasn't this gentleman's, it might be a business record, but it's still based on double hearsay. And the statements made by the inspector are not admissible.
Understood.
Okay? All right, good enough. I want to be clear about that because you should have brought the inspector in here. I mean, this is all over damages, it appears to me, right? Pretty much, most of it.
Portion, yes.
Well, you got the pet fee, you got the damage to the carpet, you got the pet rent, and you got the what do I say? The fee for not advising them of the pet. That's pretty much it. The blind, she said she owes. The countertop's only over $130. Where do you get to the back rent? Why do they have back rent?
I guess it's not necessarily back rent, Your Honor. The back rent portion would be for the pet violation.
Okay,
The rent portion of
I
$295.13.
mean, what in here tells me they got a pet? That's all I'm telling you. I want to be clear about this. They're going to come up here and tell me they don't have a pet. You got an inspector who looked at this and they're saying there's urine stains and he wasn't even there. And I sure as heck can't tell if these are urine stains or not from here. I mean, I'm not a urine expert. I'm just telling you. Nope, not yet. Let them go on and then you're going to be able to testify and ask questions. I think that this should be focusing, with all due respect, on the damages. That's what we're talking about here. He wasn't there. These pictures speak for themselves, right?
I would agree with you. The photos do depict.
I mean, honestly, I really probably should not be even admitting the photos. Because he can't testify as to whether or not they accurately represent or depict how the carpeting or how the countertop or how anything else looked on that day. He wasn't there.
That's true, Your Honor, but plaintiff's line of questioning just elicits that it is normal. and
Keep that for some other judge. Go ahead. Keep asking your questions. Let's go.
Thank you. So, sir, the inspector had prepared a report after he did the inspection. Is that accurate?
Yes,
I'm not considering that report as it relates to any conclusions that this inspector has drawn. He's not here to be cross-examined.
And I'm not asking him to testify to the content of what's in the report, only that the report itself was generated as a record that plaintiff maintains in the.
Yeah, but I would have to go through and redact, and you're not gonna backdoor this by saying, well, this is admissible as a business record. Well, great, but now I gotta redact all the things, and pretty much everything that's in there, unless you can point to me something, is based on the observations of the inspector that's going to corroborate your claim for damages, and he's not here and he's not subject to cross. I can't consider that.
I certainly understand the court's point.
It's not a point, it's true. And you guys can now appeal if you disagree. I'm just telling you, I can't. Go ahead and continue with your questioning, but you guys should have brought the inspector in. The guy that was there to observe, not some grand poobah manager, with all due respect. Just saying. I'm just saying, how can he testify?
Well,
How can he testify adequately looking at pictures? This is dog urine. How can he testify honestly that looking at pictures like this looks like it's an animal to scuff this up? How can he testify that when they needed new carpet in a place that apparently just got new carpet 15 months prior to that, or at least prior to the move out, and now they need 780 or 800 and some dollars, but now they're reducing it by about 7% to take it to 739. I'm just telling you, I'm not trying to give you a hard time. I'm just, what's fair is fair here. What else? And it's okay if you disagree with me. You're not gonna be the first lawyer in my career that's disagreed with me, believe me. Even this policeman over here disagrees with me sometimes.
Plaintiff's only argument would be, Your Honor, as it relates to the content of a business record. Literally, business records have the inherent credibility and trustworthiness because they're created in real time by a plaintiff in the normal and ordinary course.
What if somebody goes into the doctor and tells the doctor something that's hearsay? The report itself is admissible. The statements that are become double hearsay are not admissible unless they fall within an exception. I see nothing that tells me that this falls within an exception to the hearsay rule, this inspector's conclusions.
And I certainly, I agree with the board.
Thank you. Somebody agrees with me for a change.
And I'm not asking the witness to testify to anything that's not within his personal knowledge. And the court can
But you're
weigh,
putting in the inspector's report.
but the court can weigh the credibility, as the court noted.
There is no credibility of the inspector because he's not here. He has no credit. He's a piece of paper. That's exactly my point. These people got a right to cross-examine him.
In essence, the ledger.
If you had this just as rent, Mr. Grand Poopah here could come in and testify. You don't have it just as rent, hardly any of it. None of it's from rent. It's from pets. It's from pets, peeing on the carpet, living in the premises, doing whatever else what pets do, cats do.
If I may, just, Your Honor, and I'll.
Go ahead.
Sir, you would agree though, that the photos do depict damage, extensive damage to the carpet.
I can read I can read those. Tell me which ones create extensive damage. Now you're leading the witness. And I'm not trying to give you a hard time, but I'm not gonna let them get railroaded here because they got a couple of young kids and aren't lawyers. Period.
Understood. Sir, could you depict the areas precisely in the photograph.
Tell me what page and what photos, sir.
Where there's damage to the carpeting, be it either a tear or a stain. Beginning with page 1.
First page, specifically regarding the carpet, the second and third photos show stains. Same with the second page. All three photos show stains.
What about page 3?
Page 3, the first photo there is the backing of the carpet, showing stain through to the back of the carpet.
No disrespect, but he didn't see these. I can review the photos and make my own determination.
Understood. Sir, it is accurate that the defendant had entered into a written lease agreement with the plaintiff.
Yeah.
Right? And if I were to show you a copy of that lease agreement, which hasn't been yet, would you recognize it?
Yeah,
Your Honor, let the record-
Yes. What exhibit is that?
It's proposed exhibit number 1.
Plaintiff's proposed one, that's a copy of the lease.
It is.
Can you verify that?
yes, Your Honor.
All right, I'm gonna admit plaintiff's one.
Thank you. May I proceed?
You may.
Sorry, I handed you a copy. Is that correct?
Yes.
So in summation, sir, is it accurate, at least according to plaintiff's accounting, as set forth in the security deposit account statement and as set forth in the resident ledger, that defendant owes plaintiff an unpaid balance of $1,446.70?
Yeah,
Is there anything you'd like to add to your testimony here, or that you haven't already stated or said?
just that, a portion outside of damage of $295.13 is due, provided a full notice to vacate as outlined in the lease.
What, because what'd you do? Put it on is it a per diem rate? Or is it a $295.13 charge for not giving a full month's rent? Notice.
That for providing a short notice, like they didn't provide a full amount of notice, so it's pro.
Specifically say $295.13 is charged as a,
No, sorry, it's a per day,
right,
sorry,
right.
I got you, it's a per day charge.
How much is the per day charge?
If I can clear it.
Just tell me the per day charge.
Well, it would be whatever the rental rate is divided by,
And the rental rate again was what?
Is it 932, sir?
yes,
And they were out 8 days early, right?
yes,
Okay, good enough.
And sir, is it accurate that the lease agreement, written lease agreement, required the defendant to provide plaintiff with a 60-day written notice of intent to terminate prior to the expiration of the fixed lease term, if they chose to do so?
yes,
Did they provide plaintiff with that written 60-day notice of intent to terminate?
they provided notice, not 60 days.
How many days notice did they give?
They gave notice on the 31st of March, Your Honor.
So you still had 52 days, right?
Yeah.
How much is your late fees?
They're not applicable here, but it would be $75 if rent went unpaid for a month.
Okay,
And there was no charge for any late fee listed in the ledger?
Not pertaining to the late termination, the
all right.
notice.
Do you have it?
Thank you. Is there anything else you need to add for us to let the court know here today?
Just that, evidence that we have is from our normal course of business, our normal records that we keep.
All right, good enough. Do you have any questions of them? You're done questioning, right, counsel?
I am, yes.
Do you have any questions, either one of you?
I do have a question. I do remember them stating
A
that,
question.
yes,
What's your question?
where was the other rips you guys were referring to in your photos? Because from what I know, there was only one little rip by the bathroom door in the bedroom, just one.
What page is that on? Young lady, can you tell me?
I'm not really sure what pages they have. They have a whole bunch of stuff stacked up from my photos.
Page 6, Your Honor, where the chair is depicted in the first photograph.
All right, okay, so that's photograph one. Is that right?
The first quote on page 6.
Yeah.
Yes,
Okay. Right by the door jamb there, right? It looks like a door jamb. All right. Any other questions?
Not at this moment.
You can step down. Thank you.
Your Honor, may I just read?
Within the scope of within the scope of cross.
Sir, is there also a tear on page 8 as well? Top photo on page 8?
yes,
All right, and that's in a different area as well, correct?
yes,
So photo, just to be clear, on page 8 at the top is not the same photo on page 6 at the top, correct?
correct,
So two different tears in two different locations of the apartment, correct?
yes.
All right, thank you. Nothing further.
You can step down. Call your next witness. Pete, plaintiff rest.
Plaintiff rest.
Do you guys want to testify? Come on up here if you want to testify. I'm going to swear you to an oath.
I really don't know what to say because.
I'm going to have you come up why don't you come up here? Come on up here. I'm going to ask you questions more than him.
Am I allowed to bring my photos here?
You can bring whatever you want. Miranda Thompson, is she going to be a witness for you?
Yeah.
What's your name?
Your Honor, my name is Miranda Thompson.
I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you got.
Yes, I do, Your Honor.
Are you familiar with the residents? I'm sorry, with Mr. Jones and Ms. Manitak? Do you know them?
Yes, Your Honor. Miss Manatic is actually, I call her my sister. She's not blood related to me. We are just best friends from childhood. I was also a resident of the Landings, not in their specific unit. I had my own personal unit. Excuse me.
Did you ever visit, come on up here. Did you ever visit Ms. Manitak's residence that they leased over there at the Landings?
Yes, Your Honor, daily because me and Michaela actually worked together, so I was her ride to and from work
What do
every
you
day.
do for a living?
We used to, I don't work anymore. I'm actually just stay at home now. But at the time, her and I were both working. We were both employed at Gerald's Salon in Plymouth, Michigan.
All right, let me ask you a question. On how many
Yes.
occasions that they lived there, do you think you went into the residence?
I was there almost every single day, Your Honor.
Inside the residence?
Yes, Your Honor. Her and I are very close. We hung out almost every single day.
Your Honor, plaintiff would object to this witness's testimony because pursuant to the court's pretrial order, all parties were required to exchange and file with the court the names of all witnesses to be called to trial no later than May 3rd, 2025. Plaintiff filed its witness and exhibit list. I did not receive any witness list from the defendant that named this particular witness who is testifying here today.
Thank you. I'm going to still let her testify. Let me ask you, put your hand down. You can't just talk. Did you ever see a dog in the residence?
No, Your Honor.
Did you ever see a cat?
No, Your Honor.
You're under oath.
Yes, Your Honor.
You know you could be prosecuted for perjury if you're lying to me while under oath.
Yes, Your Honor.
You never saw a cat inside that property.
No, Your Honor, not once.
Have you ever known Mr. Jones or Ms. Manitak to own a cat?
No, Your Honor.
How long have you known Ms. Manitak?
We met when I was 14. I am 24 now, so 10 years ago.
And you're telling me that during that 15-month period, you were in there virtually every day?
Yes, Your Honor. I was her neighbor.
Right next door?
Not completely right next door, but I was in the building next to her, like right adjacent to her. So she was not even a 2-minute walk from me.
Do you have any questions of? You can step down, young lady. You can stay or leave. Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you got. Did you put your hand down? Now, you lived there for about 15 months at that residence address, correct? Did you ever own a cat? Did you ever own a dog? Did Mr. Jones ever own a cat or a dog? Did you ever have a cat inside of that residence during any single day when you were a resident of that property, that apartment? Was that, to your knowledge, do you know whether or not by observing it when you moved in, was that brand new carpet?
From what I saw, it looked normal, but I wouldn't say new.
And you acknowledge that you owe for the blinds, correct? And you think you paid everything else? Anything else you want to tell me?
I did speak with them before, last court hearing. They said that they would drop the pet fees. And now they're.
Okay, we don't want to talk about the pet fees now. I mean, you shouldn't talk about settlement discussions is the better response from me.
Other than that, no, I'm willing to pay like a small amount.
All right, Dawn, I don't want to talk about what you're willing to pay. Did you do anything to the countertops?
I would say I professionally clean, and I was 7 months pregnant trying to make that place thick and span as much as
I
possible.
want to ask you a question under oath again, sir. You over here for the plaintiff, you're still under oath. I'm going out of order.
Yep.
How long have those countertops been in the property?
Do not have any.
Thank you. Any questions of her, counsel?
Yes, Your Honor, a few. I mean, I've seen the photographs that were taken of your unit after you vacated. The defendant admitted in the absentee today, correct?
Yes,
And you don't dispute photos depict tears to the carpet at the door jams at two different locations of the apartment, correct?
I only saw one tear. If you would like to show me if that's possible, the other tear,
Would you like to take, do you have
Sure.
plaintiff's exhibit number 4 there in front of you?
if I do.
I'll hand it to her.
Thank you.
Thank you. Hand that to her, please.
Now I'll ask you to turn to, page number 6.
I need it for
In plaintiff's exhibit number 4. You see that?
In 1 second. Okay, I'm there.
Do you see that?
I do.
Do you see, and that's, I'm referencing to the top photograph on page number 6.
Yes,
You would agree that photo depicts a tear at the door jam, correct?
correct.
You know where that occurred, and what location of the apartment?
Yes, that is by the bathroom and the doorway to the bedroom.
Oh. So, and then I'm gonna ask you to refer to page number 8, the top photograph there on page number 8. Do you see that as well?
Yes,
And you would also agree that that photo depicts a tear at the door jam as well?
yes,
Oh. So you would agree the photo on page 6 and page 8 depict tears to the carpet at two different locations in the apartment.
no, that's the same tear.
Okay, so it's your testimony, photo on page 8 is the same tear as the photo on page 6?
Yes, that is stating, it's in the hallway to the green. That's the same door stop from where it is in page 6, so.
So you refute the agent's testimony that that's a tear, that those are two separate tears at two different locations in the apartment?
Right, that's the same location.
Yep. You've had an opportunity to view the photographs of the stains of the carpet in multiple locations throughout the apartment as well, correct?
I see some stains, but that's not on the carpet, that's underneath the lining of the carpet.
So you agree that there's stains underneath the carpet that you see depicted in the photographs?
Right.
Was there, to your knowledge, were there any fluids or anything that would have caused stains, or soiling, such as, many person or anything?
Not that I can know of, I did end up scrubbing the carpet as best as I could, from when I spilled some water. And some Kool-Aid, but that was it, these pictures that I'm seeing right here are. I'm not really sure what they are, but they're underneath the carpet, which I don't believe is from me.
You weren't the only person who lived there, were you? Who all lived there?
It was just me and, my boyfriend Deontay Jones right there.
Okay. Any children?
No, I was pregnant
Okay.
at the time.
At any point in time, were there any children that resided in the apartment with you in the codependent? But you agree that the carpeting, that the photos do depict stains.
I do see some marks in the carpet underneath, but I do not see any stains. The dark spots that you guys are seeing are from vacuum marks, from the
Yeah.
vacuuming.
Thank you. Now, when you received possession of the premises, you received an inventory checklist, did you not?
I sure did.
You didn't complete that and return it to the plaintiff, did you?
I did. I walked up to the office. I was right across the street from the office and turned in the green sheet that I was provided.
You have a copy of that here today in your records?
I do not have that door.
You heard the plaintiff's agent's testimony that you never completed and returned an inventory checklist.
I did hear that, yes.
Or is it your testimony that the plaintiff would be inaccurate?
Yes,
Who did you provide it to?
to one of the secretaries up front at the desk. I can't provide it here now because I did turn it in a while ago when I was there.
Now, you were sent discovery requests by plaintiff over the course of this pending litigation, were you not?
Can you reiterate what that is?
Interrogatories, request to admissions. What's your point here?
Did you receive requests for production of documents?
Not that I can know of now.
You didn't produce any documents to plaintiff that were requested, did you?
I was not aware of any requested documents. I did try logging into the My File that I was aware of, but it would not let me. When I did try to put in our code, it said no case found. So I was having some difficulties logging into that.
Okay, so when you completed the inventory checklist, what do you recall regarding the condition of the property?
There were some damages that I saw, within the walls and the doors. There was a crack in the bridge, I believe. I would report that to me. I don't think it had used to fix it. I didn't have to do it, so since I've seen the apartment when I first moved, and so I can't really go off by that.
One thing I didn't hear you mention was any issue with the carpet in that testimony. There was no issue with the carpet, was there?
Not that I can remember at the moment forward.
Wait a minute. So you agree that you owe for the carpet?
I do agree that I did have one tear, but I do not agree to having to replace their entire carpet.
Okay.
Thank you, Your Honor. No further questions.
You can step down, young lady. Thank you. Call your next. Do you have any other witnesses?
I just have Miranda Thompson right here.
Well, I already asked her questions, right?
Yes. I believe, she did not read her witness statement.
Oh, I can't have her really read a witness statement. If you want to ask her more questions, you can.
I really can't think of any questions.
All right, you can have a seat. The defense rests, is that right? Counsel, is that right, ma'am?
Yes.
You don't have any witnesses? No, sir? Any rebuttal?
No rebuttal.
Any argument?
Yes, Your Honor. Briefly. Your Honor, it is plaintiff's position that it's proven by preponderance of the evidence from the documentary evidence that's been admitted, that it is entitled to damages in the total amount of $1,446.70. Introduced into evidence is one, plaintiff's lease agreement that sets forth the written agreement amongst the parties as it relates to the tenancy, as well as the tenant's obligation to pay rent and for damages incurred to the property as a result of the tenancy, if any existed upon the tenancy. Number two, admitted into evidence was the security deposit account statement that set forth an itemization of the damages and charges upon the conclusion of the tenancy. We heard this witness's testimony that the defendant had provided a forwarding address and that notice was sent to the addresses provided. We also heard testimony from the defendant. There was no dispute, as a no written dispute or no written contest to that security deposit account statement. It is, number three, also admitted into evidence was plaintiff's resident ledger. That resident ledger reflects a detailed accounting from the inception of the tenancy through the conclusion of the tenancy for charges that were for charges and credits to support the claimed amount of $1446.70 that's being sought in the pending action, including the reference to the unauthorized pet fine, the non-refundable pet fee, and the assessment of pet rent. Now, I understand, and I would suggest that the court can, through the credibility of the evidence, also introduce the photos taken in the ordinary and usual course of plaintiff's business, which clearly depict damage to the carpet. We heard the agent testify that the carpet was brand new upon the inception of the tenancy when the defendant took possession. Photographs, as the court noted earlier, do speak for themselves. We heard the agent testify that there were tears, the door jambs in two separate spots. We see multiple staining throughout the carpet. We even had the defendant admit that the backing of the carpet does show stains, even though the defendant was not able to testify where that came from or how that occurred. So the photographs speak for themselves. Also, finally admitted into evidence, Your Honor, was the receipt for the replacement of the carpet. It is plaintiff's position, Your Honor, that it has proven by preponderance of the evidence that it is entitled to $1,446.70, and accordingly, plaintiff would respectfully request the court grant judgment for that amount and enter it against the defendant.
Thank you. Anything you'd like to say, either one of you?
Well, they're still on about the carpet and the stainings. It did list on their end in their notes for the pictures that they were urine stains, which we already went over that we do not have any pets living in the home. And they were false about the statement of it being two rips in the carpet. It was a picture of one rip less from different angles.
Any rebuttal? Counsel?
No, Your Honor. I would rest on the testimony of plaintiff's agent that those were two separate spots. And I didn't give any cross-examination by defendant, plaintiff's agent that would suggest otherwise.
Defendants acknowledge, at least Ms. Benatak acknowledged.
And am I allowed to show you my pictures that I have?
You know what, at this point, it's okay. I'm gonna rule, okay? She acknowledged that the blinds were damaged. And you claimed 2787 for blinds. There was some urine or some kind of stains on the carpet. There was a couple of tears. All damages told, I'm giving you 125. I find there was no cat, has not been a cat. And they owe nothing for cat fees. 43.56, 20 and 55 were the costs. 243.56 is your total judgment. That's it. Thank you all. Have a good day. Thank you.
Thank you, Your Honor.
I'm sorry, Your Honor.